Hi all, this is Ron, I'm back. Well, the subject for the lesson of this week is one that I've had hundreds of questions on over the years. It's one that people totally get confused about, and yet it's important because it's about land trust. And what I'm going to talk about in the next few minutes is how you should take title to a piece of property in all states other than Pennsylvania. Pennsylvania makes it too onerous to do this, so if you live in Pennsylvania, you might as well turn this video off right now and go on back to the newsletter and going down to the next section, because what I'm talking to you about here will not apply to you. But if you live in any of the other states, it does apply to you. So let me first talk about what is a land trust. A land trust is a very simple entity designed to take title to a piece of property. That's all it is. It does not require a federal ID number. It does not require a tax return. It does not require a filing for any federal or government use. There's no bank account that goes with a land trust. There's no EIN number. There's no nothing. It's a simple document, and everybody wants to complicate it. Now, the thing about a land trust is that it is designed to give you privacy. In fact, it has several advantages. First, you get privacy because your name is not on the deed that gets recorded down at the courthouse. The trustee's name is on there as trustee. There's only one place your name goes, and that's in the land trust agreement in the back of it, where it calls for the beneficiary of the land trust. Now, I have the two documents that are going to be involved in a land trust in my hand. This is the warranty deed to trustee. This one gets recorded at the courthouse. If this does not get recorded, your property is not in a land trust. The second one is the agreement and declaration of trust, which really just defines the terms of the trust. It tells who the beneficiary is, who the trustee is, and then all the legal gobbledygook that you could read when you get a chance. And you'll see that it's not a complicated document. Now, the good news is that this document, the agreement for declaration of trust, goes in your filing cabinet. So you see, this is the only place the beneficial interest is. This gets recorded at the courthouse. This is the warranty deed to trustee. The whole world sees this, but your name as beneficiary is nowhere on this document, period. The trustee signs it as trustee. Well, I'm sorry, that's not even true. If you're receiving the property into a land trust, the seller signs this deed. You don't, or the trustee doesn't. The seller is the only one that signs a deed. Buyers don't sign deeds. Now, this warranty deed to trustee is a document that I have right available for you, but there are a few states that will have their own deed to a trust, such as California calls them grant deed to trustees. I would prefer that you use a deed to a trust when you take title, but I will confess that that's not always going to be the case. For example, if you go down to an auction and buy a property, you're going to have a miserable time trying to get them to use your deed to transfer title from them to you. It's probably just not going to happen. So I'm going to tell you how to fix that. I'm going to tell you exactly how I do it. But let me come back here for a moment. Well, or first you better figure out where to get these documents, hadn't you? You can pull these off of your Gold Club site. They're right under forms and agreements. The deed is there and the agreement is there for the trust. And anybody can look through these and fill them out. You don't need an attorney to fill these simple documents out. You should have an attorney prepare this deed, because anything that gets recorded should probably be prepared by an attorney. It's got to be done right. So this is simply the deed you hand your attorney when you get ready to take title, if possible. Again, won't happen with bank-owned properties involved. But let's say you're taking title to a property subject to. Absolutely use this deed or the attorney's version of it, because this deed is a deed to a trust. This has trust language in it that establishes that the trust exists. And don't confuse it with a deed of trust. And I know that's confusing. A deed of trust is a lien against the property. A deed to a trust is the actual document that transfers ownership from the seller to the buyer. So these are the only two documents you need. This one you will put in your own filing cabinet. This one your attorney will prepare and record for you. When this is recorded, your property is in a land trust. Whether you fill this out immediately or not is up to you, but you should fill this out, put it in your filing cabinet, because it discloses who the beneficial interest is. Now, why use a land trust? Well, number one, privacy. As you can see, no one knows who the beneficial interest of the trust is, because on the deed it does not mention who it is. So they can't find out unless they ask the trustee So I'm going to suggest that your trustee be your corporate or your LLC. You can have your entity be the trustee and you can be the beneficial interest. However, the trustee cannot be the beneficiary or vice versa. If you do, you don't have a trust. But an entity is not you. So I always use an entity as my trustee. Now some states want you to have an individual as a trustee. To be honest with you, I'd use an entity anyway. Besides, who's going to spank you? Who cares? The only one that can dispute it is the beneficial interest, and that's somebody you know very well. I want an entity to be the trustee. And I'm not your attorney, and this is not legal advice I'm giving you. You check with your own attorney if you can find one who understands this. But that's the way I do it, and the way I've been doing it for years, and the way my students are doing it all over the United States. Incidentally, guys, if you're from Canada, won't work in Canada, you're going to have to take title in an LLC. Same in Pennsylvania. So let me get back to it. What's the advantages of a land trust? Privacy is number one. Number two, if I were to transfer this property to an investor, I literally don't have to change anything down at the courthouse because the property is already deeded to a land trust. All I do now is go in my forms and agreements section and pull out the assignment of beneficial interest and fill it out and hand it to my new buyer if they understand land trust, and I have zero transfer tax down at the courthouse. The world doesn't even know that the beneficial interest of the land trust has been transferred. The trust still owns the property, it's just that the ownership of the trust has now changed hands. So when applicable, that's a great benefit of having a property in a land trust. The biggest reason, however, is privacy. And as far as asset protection goes, privacy is a good start to asset protection. If someone checks the records, they won't find your name on public record as the owner of a property. And the only way that they're ever going to find out that you are the owner is if they call you in the court and depose you and ask you if you're the beneficial interest. So you do have that degree of protection, but don't be under the assumption that because your property is just in a land trust that creditors and predators can't get at it. Not true. If they find out you're the beneficial interest, they still can. So why use it? Because it costs nothing to use it. It costs not one dime more to use a land trust than it does take title in your own name. So why on earth would you want to take title in your own name? Let's just suppose this. Let's suppose you had 10 properties in your own name, or worse yet, you and your spouse jointly. 10 properties down at the courthouse record recorded all in your own names. Now let's suppose you had tenants in one of those properties, and I don't know, let's say you had a fire one day, and the house burnt down and 2 children died in the fire, God forbid. Smoke alarm didn't go off. Here comes a lawsuit. Lawsuit will be against the homeowner, which will be you. And if it happens to be you and your spouse, it'll be against both of you. And you say, but I got insurance. And then I would say, oh really? First of all, have you tried to collect on an insurance policy lately? And if you do collect, they all have a limit. And that's after the lawsuit is long over, and hopefully there's enough money in your policy to even pay for your legal fees. I doubt it. But even if there is, if they find fault, they're going to get a judgment. And I can almost assure you that the judgment they would get in a case like that would be bigger than the limit on your insurance policy. So if that's true, what happens next? Well, they get a judgment against you and your wife personally. And my friend, if they do, that judgment immediately attaches to everything you and your wife owns, which means all 10 of your properties that are in your name are now attached with this great big lien from this lawsuit that you really were innocent about, but still have to pay the price. Now, let's suppose 10 houses are in 10 different land trusts, all in different baskets. Now what happens on one house doesn't affect the other 9 houses. A judgment against you will not attach to a property you do not own. You do not own these properties. A trust owns the properties. You just happen to own the trust. So a judgment against you will only attach to property you own. By not owning them, no one can put a lien on them because of something that happens to you personally. Now I know that was a quick down and dirty seminar there, and by no means is that everything you need to know about land trust, but at least it's a good start, and I hope it's a good enough explanation to get you to the point to where you start thinking about taking title in your own name, and you start thinking about simple, in fact not inexpensive, free protection devices such as a land trust to start your asset protection plan. And then again, it is just a start. If you want to learn more about asset protection, entity structuring, and estate planning, get to our entity structuring event where we spend 2 days with a national law firm that we put together for you. And by the way, if you're not a Gold Club member and you want to get the trust agreements, I got a great deal for you right now. Go to ronsdollardeal.com, spelled out, ronsdollar, D-O-L-L-A-R, deal.com. And not only can you register, get into the Gold Club there, but for $1, you'll get my entire wholesaling course, which is a $600 course for free. So this would be a great time for you to be a Gold Club member if you're not. And as soon as you become a member, all my forms and agreements are right there available for you to print out and fix as you see fit, email to your attorney, along with another huge host of benefits. So if you're not a Gold Club member, what are you waiting on? Get over there and get registered. ronsdollardeal.com and get my $600 course for free. And then we'll have time to spend more time on this land trust thing to make you an expert at it. See you next time.